Data shows that there are 6,006 crimes per 100,000 people in Canada, and in 2016, there were 1,895,546 criminal code violations in Canada, and that's not including traffic offenses. Crime happens every day, and although Canada is deemed a relatively safe country, 8th in the world actually, it doesn't mean everyone follows the rules. I can't guarantee I'll cover everything unless you want a long, complicated movie, but included in this video are aspects of the criminal justice system that I have learned about during my field placement at the probation office. This is the process of justice. When a person is found guilty, the probation officer will prepare a pre-sentence report, or PSR, to help the judge understand the offender and decide what sentence would be appropriate. PSRs can take a while as probation officers have to interview offenders, family, employers, etc., and create somewhat of a biography. This can take even longer for children as there are multiple people that they interact with that can contribute to this. There are 4 different types of PSRs. Comprehensive, which is the fully written out PSR and the ones that they normally write. 2 is a focused PSR, which focuses solely on the main problem, such as the drug problem or theft. 3rd is addendum, which is an update to the PSR written on 1 page to add to the original PSR if it is less than a year old. And 4th is verbal, which is a PSR that is verbally told to the judge. The purpose of a pre-sentence report is to provide a picture of the accused as a person in society, his background, family, education, employment record, his physical and mental health, his associates and social activities, and his potentialities and motivations. The function isn't to provide evidence of an offense, give details of a criminal record, or tell the court what sentence to give. Once a PSR has been completed, offenders are assessed with a level of risk case management inventory. It's a type of form that consists of 43 sections condensed into 8 categories in Section 1. There's criminal history, education and employment, family and marital, leisure and recreation, companion, alcohol and drug problem, pro-criminal attitude and orientation, and antisocial pattern. The items are scored as either 0 for absent or 1 for present. Assessors assign these scores based on interviews and file reviews. One of the reports would look like this, with a score for each category, and eventually it would come out to an overall risk level score as seen here. There are different court setups depending on the courtroom and what kind of situation it is. In a normal common court occurrence, the setup is like this. The judge is in charge of the court. He or she listens to what is said in court and decides if the accused is guilty, unless there is a jury that makes the decision instead. The court officer helps keep everyone safe. If the accused is being kept in jail, the court officer will escort the accused to and from the courtroom. Sitting near the court officer is the court clerk. This person helps the judge in the courtroom by making the court schedule, calling the court to order, or reading the charges against the accused. At these 2 tables are the prosecutor, which is a government lawyer who presents the evidence to show that an offense was committed by the accused. This person may also be called a crown attorney. Beside them is a defense lawyer, who is a lawyer that represents a person charged with a criminal offense. Behind them is the public gallery, which is a seating area in the courtroom where members of the public may sit to observe what happens in court. Also, some trials involve a jury. The jury is a group of 12 people who listen to what is said and decide if the accused committed the offense. In a lot of court proceedings that I have seen, it is just the offender and the judge, along with the defense and prosecution. The prosecutor will state the facts about what the offender did, and the judge will make a decision. A lot of the times, the prosecution and defense will actually come to a mutual agreement beforehand and present it to the judge, who agrees with it most of the time and sentences the offender. There are different types of sentencing an offender can get. Absolute or conditional discharge. The court can order that an accused be discharged of an offense after finding of guilt, and no conviction will be registered. Conditional or absolute discharges may only be ordered for less serious offenses. The court has the option of imposing a conditional discharge. This adds specific conditions or rules to address the accused's conduct that led to the offense. For an absolute discharge, they have no conditions. Suspended sentence and probation. The court may choose to put off or suspend imposing a sentence and release the offender on probation for a specified length of time. The court may also include a fine or conditional discharge with the probation order. A fine is a set amount of money that the offender pays to the court as a penalty for committing a criminal offense. A fine may be combined with another penalty, such as imprisonment or probation. Fine option allows young people and adult offenders who are unable to pay the fine to do work or volunteer for a nonprofit community or government organization. Conditional sentence. Where a person is convicted of an offense and the court imposes a sentence of less than 2 years imprisonment, the court may order that the sentence be served in the community with certain conditions instead of jail. Alternative measures. The purpose of alternative measures is to promote a sense of responsibility in the offender and an acknowledgement of the harm done, and to satisfy the important objectives of public safety, deterrence, denunciation, rehabilitation, and repetition of the victims and the community without going through the formal court process. Imprisonment. The court may sentence a person convicted of an offense to jail. An offender who is sentenced to less than 2 years serves the sentence in a provincial correctional institution. An offender sentenced to 2 years or more usually serves the sentence in a federal penitentiary. Intermittent sentence. Where the court imposes a sentence of 90 days or less, the court may order that the sentence be served intermittently, or in blocks of time such as on weekends. This allows the offender to be released into the community for a specific purpose, such as going to work or school, or caring for a child, or for health concerns. Victim surcharge. A victim surcharge must be ordered at sentencing. The amount of the victim surcharge is 30% of any fine that is imposed on an offender. If no fine is imposed, $100 is charged for a summary conviction offense or $200 for an indictable offense. Restitution. Restitution is the money the court may order an offender to pay the victim for money that the victim lost as a result of the crime. The most predominant sentencing is probation. An offender who gets a conditional discharge or a suspended sentence will always have a probation order that they must follow. A probation order can also be combined with a fine, conditional sentence, intermittent imprisonment, or imprisonment. The maximum length of a probation order is 3 years. In many cases, they are 1 or 2 years long. Every probation order will have the following conditions: keep the peace and be of good behavior, appear in court when ordered by the court, and tell the court or probation officer about any change of name, address, or job. Other conditions sometimes included as part of the probation order are: report to the probation officer, sometimes every week or month, not buy, carry, or drink alcohol, not have or use drugs that aren't prescribed by a doctor, not have or carry any weapons, perform community service, stay away from a certain person or persons and not go to their house or where they work, not to call, text message, or email a certain person or persons, give money back to the victim, and go to counseling or rehabilitation. In a lot of the probation orders, the judge will make the offender report to a probation officer. If an offender has a condition to go to counseling or do community service, or if the judge feels they need supervision, the judge will usually make the offender report to the probation officer. Reporting is usually every week or every month, but it can be more frequent or less often. This is usually determined by the LS-CMI score that we discussed earlier. With every crime comes a victim, and as someone who has suffered physical or emotional harm, property damage, or economic loss as a result of an alleged or proven crime, victims are an important part of the criminal justice process. Some things that are provided by victim services include information on the criminal justice system, referrals for counseling, court preparation and support, information on sentencing outcomes, financial benefits and remedies for victims of crime, notification of hearings and offender release, making a complaint, and assistance in preparing a victim impact statement. A victim impact statement is a written statement that a person affected by a crime can prepare for the court to consider when sentencing an offender. A victim tells the court in his or her own words about the harm done by the crime. Victims may include pictures or drawings to help explain how the crime affected them. There is a lot that goes into the criminal justice system, and I definitely just scratched the surface. I feel that many people don't understand all of the different parts that work together in the process of justice, and I hope this video helps you understand what I didn't before going into this field placement. Stay out of trouble!